not being personal, but I want to assure you that somebody in that position ought to show some penitence, ought to show some remorse, ought to throw away arrogance and self-serving attitudes. The court is further urged to take judicial notice of the fact that the convict established Radio Biafra, a broadcasting platform operating on several digital channels, including mobile radio, Twitter, YouTube, Facebook, WhatsApp, blogs, and Instagram. It is a station with global reach. Evidence before the court, my Lord, shows that when the convict was arrested on 15 October 2015 at the Tulip Hotel in Lagos, he was found in possession of broadcasting equipment. The conduct of the defendant through online publications, live broadcasts, and social media communications constitute act of incitement, encouragement, and provocation of terrorism as defined under the Act. It is the view of the prosecution, Lord, that without the instrumentality of the internet and social media platforms, the magnitude of destruction, division, and human losses recorded in southeastern states of Nigeria, including Lagos, would not have reached the level it attained. The digital platform becomes tools in the hand of the convict, tools of radicalism, ethnic hostility, and incitement to terror. Their amplified reach resulted in a coordinated transnational militarism or militarization of violence and destructions of public property across several states of Nigeria. The court has both the power and the duty to restrict further access to digital media through which the offenses were committed by making orders that prevent the commission of similar or related offenses, including forfeiture, confiscation, or restrictions of the means used to commit the act of terrorism. As a form of preventive control, the prosecution praised this honorable court to impose restriction on the convict's access to digital devices, online accounts, or internet facilities. In other words, my Lord, anywhere he may be kept until his execution in obedience to the sentencing, if he has access to these devices, and they are cheap and easy and available everywhere in Nigeria, there will continue to be broadcast. Maybe he will claim he was not the one. At the moment, if you open to YouTube, you see a lot of rascals talking about the proceedings of the court, trying to twist and misread and mislead the people with what happened in court. So we're asking that your lordship should restrict him from having access to these devices. This honorable court, my Lord, has the statutory power to prevent convicts from further committing offenses by making orders for the forfeiture, confiscation, and restriction by any means used for communication. We therefore pray that the court to order the forfeiture of all the broadcasting equipment, digital devices, and all electronic materials seized from the convict and currently in the custody of the Department of State Security, State Service. In particular, the radio transmitter, Trans 50L, unlawfully imported into the country, should be forfeited to the federal government of Nigeria. My Lord, we want to say, sir, with all respect, that it might be argued that access to information, access to digital devices may be argued within the constitutional rights, but it's not absolute. So therefore, sir, if your lordships want to order his restriction, your lordship may give him a right to acquire any, but with the permission with the authority of National Security Advisor and the Controller General that for the safety of the convict, for his safety, for his security, and for the protection of his life until the sentence is executed, I respectfully, sir, as prosecutor, plead with your lordship to direct that he be kept in the safest custodial center anywhere in Nigeria, because his safety is very important. Your lordship need to take judicial notice of what happened when Simon Ekpa was sentenced in Finland. There were lots and lots and lots and lots of talks and talks. The convict has enemies. He has friends. But no one can say the volume or the number of his enemies who may want to eliminate him. So we're asking, my lord, that your lordship order the government of the Federal Republic of Nigeria to keep him in the safest custodial center anywhere in Nigeria. You know, and if I may say with all sincerity, I am not too sure that Kuje, where there have been jailbreaks, will be the ideal place. So I'm urging your lordship with all sense of responsibility to preserve his life until he answers his sentence. So I thank your lordship, and I pray that the incidents of terrorism will cease from Nigeria, from north to east, to northwest, to north central, and as we see, may God spare Nigeria of disintegration. Lord, I want to thank you. I want to appreciate you on behalf of my colleague, Adebayo Ojo, and Suraj Saida. We're grateful to your lordship for a well-researched, a well-reasoned, and a courageous judgment. Thank you, my lord.
There is no doubt that the convict has waived his right to be present through his unruly attitude, the habitual unruly attitude to be in court when the judgment was read. But we must still give him opportunity to hear one or two things from him, but not personal through his person. Since his consultant is here and the offense has to do with death sentence, I will call his consultant that was his lawyer before he converted him to consultant, if he has any allocutors to make on his behalf. Mr. Ejimako, do you have any allocutors to make on his behalf?
My Lord, being an officer in this temple of justice and not being properly dressed and not being his counsel of record, I will yield this very task to Honorable Obinna Agocha, who is better qualified than me being the member of House of Representatives who represents Mazi Nnamdi Kanu.
It's okay. Honorable, let me have your full name and restrict yourself to allocutors.
Yeah.
Allocutors is what will mitigate the sentence. Is our brother. Let us consider, let us hear you. You tell us your name. We can't, because of your ruling behavior, deprive him of allocutors. Can I hear from you?
Thank you, my Lord. My name is Right Honorable Obi Agocha. I represent the good people of Iguano, Umuahia North, and Umuahia South Federal Constituency in the 10th National Assembly. My Lord, I am the direct representative of Mazi Nnamdi Kanu. That's why you see me here almost every time, showing presence and also showing solidarity with him. The matter has come to a closure for now. I'm not his lawyer. I wouldn't know whether they will seek appeal. But for now, the Lord, he's my brother. He's my friend. I went to school with him. We attended primary and secondary school together, though he was my junior. But it is my responsibility and obligation as a member of the National Assembly to represent him as well. My Lord, I plead for mercy, I plead for clemency, and I appeal for peace and for stability of not just the Southeast, but as well as Nigeria. Like the prosecutor said, Nigeria is bleeding over the last few days, and we must bring some of these issues to bear and to understand how to find common solutions to our common problem of terrorism. I also wish to appeal to the prosecution team that it has been done to Mazi Nnamdi Kanu. The other people out there also doing more worse than him.
Please,
sorry, sir.
I asked for a locutor.
Yes, sir.
Please, don't
so, I apologize, sir. So I want the court to take judicial notice of that this trial has gone on for almost 10 years. Mazi Kanu is almost 56 or 57 years old now. He has been absent in his family life, his children, his community, his family. So I plead for the Lord to show mercy, to temper justice with mercy. And as we move forward, it shall be great for our country. Thank you very much for the opportunity. I'm a friend of the court, having come from the other side of the government. So thank you for giving me the opportunity to address the court. Thank you, sir.
Thank you. I will consider all this, and I will rise and come back by 10 minutes to 4. You may go and come back 10 minutes to 4 for the sentencing. I will rise and come back.
Just witnessed the live broadcast of played out at the Federal High Court at Justice James Omotosho's court, where Mazi Nnamdi Kanu, the leader of the proscribed Indigenous People of Biafra, has now been convicted on all 7-count charge bordering around majorly terrorism. And you saw the
raised here in the application, safety application for bail, have been raised by the defendants severally in this court. And this court has made an order that all preliminary objections or issues shall be taken during the judgments. This court is bound by that order. However, the issue as regards to referral of questions to the Court of Appeal and the stay of proceedings statutory law governing criminal procedure in Nigeria, to its Administration of Criminal Justice Act 2015, by Section 306 of that Act, which provides that an application for stay of proceedings in respect of criminal matters before court shall not be entertained. This statutory provision was initiated by the Court of Appeal in the case of Shuaibu versus Federal Republic of Nigeria. I must speak as to the essence, the reason for this statutory provision, that is Section 306 of Administration of Criminal Justice Act. The essence of this provision is to prevent inordinate delay through the filing of appeals while trial is going on. For this reason, the Section 306 of Administration of Criminal Justice Act have been provided that such application shall not be entertained. This court shall not entertain sale. As regards to the application seeking for bail, we have different types of bail applications. Bail application can be bail pending trial or bail pending appeal. I've looked at the application for bail. This application before this court does not fall within those two classes of application for bail. In this matter, as also stated by the defendant, that he has put in his defense. Hearing has been concluded. And also, by the order of this court, on the 27th day of October 2025, the court made an order that the defendant should negate putting his defense, or if he's not putting his defense, he should file address which shall be deemed to be final address. The defendant portion to that filed motion and comprehensive address. It is based on this that I hold that issues are relieved is highly unmeritorious. Same is hereby dismissed. Like I said earlier, all other issues have been raised through that motion and comprehensive final address that was deemed as final address, and another motion filed thereafter. This court, in the interest of justice, will not close his eyes to see. The court will determine all this issue in its judgments. I proceed, I deliver my judgment. Judgment, please.
My Lord, I have an objection. Final written address is a constitutionally mandated right which I must be granted. It is in the constitution of this very country that final written addresses, my Lord, must be granted. I have not waived it, my Lord, and I insist that I address this court on all these issues. My Lord, do not forget.
Defendants?
My Lord.
Consultants, can you tell
My Lord, I'm not, please, let me finish. It's my case. It is my case, my Lord, let me finish. My Lord, in this very court, Emeka Itiaba SAN was here, my Lord. Emeka Itiaba SAN said, at the right time we will contradict or controvert a piece of evidence. A piece of evidence given in this very court. I need to write my final written address, my Lord. I must.
Count charge which reads thus.
My Lord, my Lord, I'm saying it clearly.
Defendant.
I am entitled to final written address.
Defendant.
What is my final written address? It's in the Constitution. My final written address.
Defendant.
My Lord, my final written address. Where is it?
Can you listen to the
I'm not, my Lord, please.
Can you listen to the court?
Please, my Lord, I need to file my final written address. It's in the Constitution.
I appeal to you to compose yourself this temple of justice.
My Lord, you are biased. You are biased. This is not law. You are biased. It's not law.
Please, I beg you to comport yourself.
My Lord, this is not law. Show me where it says you can waive my right to final written address.
I beg you to
Show me.
comport yourself.
Show me where it says you can waive my right to final written address. And I'll sit down. Show me. My Lord, you are conducting their case for them. You are the one running their case for them. Let them show me that the prosecution, show me where it says you can waive my right to final written address. And I'll sit down.
You have the right to appeal after
No, my Lord. This is a perversion of the cause of justice. This is not law. It is not law.
Can you excuse me?
My Lord, I cannot excuse nullity and illegality.
Can you let him
It's not possible. It is not possible, my Lord. You must show me where the Constitution says you have the right to waive my written address. You must show me.
Excuse him.
Show me. Show me where it says so. Show me. Show me where it says so.
Excuse him.
Is that why you brought the cameras? Is that why you brought them today?
Please.
You didn't bring it before. You brought it today.
Please.
Show me where it says you can try me on a repeat law. Show me.
Please.
Show me where it says you can try me on a repeat law. I said, show me. Show me. Show me.
Get the microphone from him.
No, leave it. Leave it. Leave it. I said, leave it. It's a court of law. I'm under trial. I'm under trial. I have to speak. I'm under trial and I have to speak. Listen to me. Listen to me, please. I'm under trial. I'm under trial. I'm under trial. And I must address the court. Wait. No, listen to me. Please. The judge must listen to me. No. Wait. Wait. I'm asking a very simple question. No. Wait. Please. Look, this is Supreme Court. Wait, hold on. This is Supreme Court here. Hold on a second. Hold on. I said hold on.
May I inquire?
This is not a court of law. It's not a court of law. What you're doing is not law. You don't know the law. Show me. I said show me where you have the right to waive my right to final address. Show me. It's what the Constitution says. Show me. Show me. You cannot show me. You cannot show me. You cannot show me because you don't know the law. You can't show me. Wait, hold on a second. Don't touch me. Don't you dare touch me. People who don't know law, show me where it says you can waive my right. Show me the place I'm asking you. Show me. Show me. Show me. Which law says you can try me an unwritten law? Show me. You cannot show me. And you're a judge. You claim you're a judge. You don't know law. You don't know law. Nonsense. Where is the final written address? Where is it? Which law gave you the right to waive my final written address? Which law gave you that right? Nonsense. You think I'm trying this with illiterates and you try with me? You are mad. What's this one doing here? What are you 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 doing here? Ask me what are you doing here? This is the idiot that attacked me. This is the fool that attacked me. That's the idiot that attacked me. That's the fool. Don't touch me. Don't push me. I'm going. Don't touch. Don't touch me. I'm warning you. Don't touch me. I'm warning you. Don't touch me. Don't touch me. Don't touch me. I said don't touch me. Don't. Smart people. You don't know law. Show me where it says you can waive my right to final address. Show me the law. Show me the law. I want to show me the law. You don't know law. They are reporting you. You are writing rubbish. Show me the law. Unaddressed affidavit. You say you waive it. Are you doing their job for them? God will punish you now and forever. Any judgment, let it be on record. Any judgment given in this court is rubbish. God will punish you now and forever. Criminals. Any judgment, let it be on record. Any judgment given in this court is rubbish. Ask him where is the law. Ask him what to show. Where is the law?
Although I'm not really persuaded, but I must temper justice with mercy. The court is moved by chapter 23, verse 23 of Matthew, in the book of Matthew, to the fact that, who unto you, scribes and Pharisees, hypocrites, for you pay tithes of mint and anise and cumin, and has omitted the weightier matter of the law, judgment, mercy, and faith. This you ought to have done, particularly, and must notice the word in Matthew 23 and verse 23, the word mercy. Our Lord himself is merciful. No matter what we do, he is a merciful God. It is on that note that the court will follow this above admonition of Jesus Christ in the above passage and show mercy to the convicts. In addition, the death penalty globally is now being frowned upon by the international community. Consequently, and in the interest of justice, I hereby sentence the convicts to life imprisonment for the said counts 1, 4, 5, and 6 instead of death sentence. Life is sacred to God. With respect to count 3, he is hereby sentenced to 20 years imprisonment without no option or fine. For count 7, he is sentenced to 5 years imprisonment without no option or fine. To extend the mercy, I hereby order that the sentence shall run concurrently. And due to the nature of the offenses that borders on terrorism and the attitude, violent nature of the defendants that I have taken judicial notice. The last adjourned date, he was so unruly and expressed violence, even was about to beat the security officers there. This morning, he repeated same.